All right, welcome everybody. This is Deidre Diamond. I am so excited to be here moderating this discussion with Dawn and Erin, who I am going to introduce here in just a moment. Everybody, Dawn, Erin, you can hear me? We're all live?
Yes, we can.
Hi, everyone.
Awesome. So, Dawn, Erin, it's been quite a few conversations that we've had together creating this to help solve some real questions that our community has. So I want to thank you personally as somebody who not only runs a staffing agency, but also spends a lot of time thinking about job seekers and their experience. This topic is really front and center to the community, and so thank you for taking the time to help us understand it at a greater capacity. I'm going to go ahead and introduce you both. So on the webinar, we have Don Schroeder, and Don is a partner at Foley & Lardner. He specializes in labor and employment law. So Don, thank you so much for joining us.
Thanks a lot.
And Erin Horton, also with Foley, working closely with Dawn as an associate, also focusing on employment and the laws specifically around wages and hours of policies. So we've got two experts with us, everybody, and they're going to help us understand this because it's complicated. So we've got on the call joining us from all over the U.S. We have, folks who are in the staffing business. We have employers, and we have folks that are right today in process of job seeking. So we've got lots of questions that we're going to answer. If we can move into the agenda slide here to share with everybody. The idea today is to make sure that we walk away from this conversation understanding why do we have the Equal Pay Act? What is it? Why does this law exist? What are the laws, both state and local? What are they? And then how do these laws affect job seekers, employers, and staffing agencies? So we've got a lot to cover, and we're going to take questions, and what we can't get to, our experts are going to follow up and respond and give answers to, and maybe even we'll have follow-up webinars. We'll see how it goes, because I think that there's a lot to get to. So if we don't have enough time, we'll make sure that we follow up. So on that note, send your questions. Happy to take them as we go. And let's start here with the wage gap explanation. And let's, Erin, take away and tell us why this exists. What is this?
Thanks, Deidre. So there is a wage gap. If you haven't heard about it, on average, women are now earning approximately 80 cents for every dollar paid to men. So despite efforts that have been made in the past, we're still dealing with a very stubborn wage gap between men and women in the workplace. And this gap exists seemingly regardless of geography, occupation, education, or work patterns. So it's crossing all different boundaries. It also is worse, in particular for women of color. So there is a problem here that not only the federal laws have sought to address, but also state and local laws, and we'll get into that in more detail.
Awesome. Let's do that. Let's tell us more.
So we'll start with the federal landscape and what the feds have been trying to do here. Since 1963, believe it or not, we've had an Equal Pay Act on the books. It's designed to prohibit discrimination on account of sex in the payment of wages by employers. In particular, it prohibits employers from paying unequal wages to men and women who are performing what it calls substantially equal jobs and who work in the same establishment. Substantially equal jobs generally is referring to jobs that require similar skill. This could be experience, ability, education, training, similar effort. It could be physical effort or mental effort, and similar responsibilities. And they have to be performed under similar working conditions. The Equal Pay Act that's been on the books since '63 allows certain kinds of wage differentials if they're based on a seniority system or a merit system, a system that measures earnings by quantity or quality of production, or any factor other than sex. And that's where I'll get into a little bit more detail, but that's where we get into some trouble, any factor other than sex. So it's not that there can't be any wage differentials between men and women, but they have to be based on these limited circumstances. The remedies under the Equal Pay Act include back pay, attorney's fees, and then 1 times the back pay for liquidated damages if it's found that the discrimination was intentional. Right.
Fascinating.
So, this has been around since 1963. So the question that may be on your lips is why are women still earning only 80 cents on average to the man's dollar? Why hasn't the EPA closed this wage gap? Part of the problem is in judicial interpretations of what a work establishment is. A work establishment could be, and has been interpreted in the past to be, one building versus another building. So you could have 2 buildings right next door to each other owned by the same employer, and if somebody works in one building as opposed to the other one, that could be used as a justification for paying them more or less. So some employers have been a little cute with the definition of work establishment. Judicial interpretations have also allowed the terminology factors other than sex, which, as we just discussed, wage differentials can be based on a factor other than sex. But some judicial interpretations have allowed that to include factors that aren't even job-related. And that could include things such as the individual's compensation history. Retaliation provisions in the EPA only protect employees who initiate a complaint or a lawsuit. So it's not going to protect employees who are talking with one another about what their salary is. So it would be very difficult for a woman, for example, to try to get a sense of whether or not she's not being paid dollar for dollar with her male counterparts. So class action provisions also require plaintiffs to opt into the class as opposed to opting out, and that's just an extra procedural hurdle under the EPA. And the remedies are also limited. They do not include punitive damages or compensatory damages beyond back pay. So the EPA, really doesn't have the teeth that a lot of people hoped that it would have. In response to that, for many years now, ever since 1997, we've introduced the Paycheck Fairness Act. It was reintroduced this year as well. There's no reason to expect that it will have any more success this year in passing than it has in the 20 years past. But what this would do is deal with some of the issues that the EPA has suffered from, including updating the definition of what a work establishment is to basically specify that you can't just have separate offices. It has, if you're within the same county or subdivision, you would still be considered the same work establishment. It would seek to clarify the factor other than sex defense to ensure that it has something to do with the job at issue and to preclude reliance on salary history. It would strengthen available remedies to include full compensatory and punitive damages, things like out-of-pocket expenses resulting from the discrimination, and compensation for non-economic damages, such as things like loss of reputation, mental anguish. It would update the class action provision so that you wouldn't have to opt into the class. You would automatically be in it and then would have to opt out. Makes it much easier procedurally from a class action standpoint. And it would broaden the retaliation provisions to include any kind of conduct of employees to disclose their salary information to others. So an employees that are discussing their salary with one another would be protected under this law if it were ever to pass.
Interesting. So this is a real hot button for job seekers today, and certainly for staffing agencies who live in the middle between employers and job seekers really seeking to help, which is the age-old question is, what's your salary history? And, and sort of everybody knew that the way that salary was identified was that a hiring organization would say, okay, what are you currently making? What's everybody in my team and in the company making at that, at similar levels? And then what's our budget? And that's how income would most of the time, or excuse me, the salary offering would most of the time, that's how a company would come up with the number, let's say. So now here, these laws get stronger. How does a job seeker answer the question, what are you currently making? Let's start there. How do they ask that? How do they answer that question to anybody, to a staffing agency or an employer who they're applying to work for?
Well, I think, if it's the job seeker, I mean, one of the things you have to take in mind is, and perhaps depending upon what jurisdiction you're in, federal, state or local, because I'll get into the state laws and how they are varied with respect to answering some of these questions. Obviously, you would want to, if there was a state where you're prohibited from really asking that, I think one of the general ways to do it is really laying out your expectations based upon where you currently are and what your expectations are going forward, and stating that either in brackets or trying to provide a more general answer, and hopefully that you'll then spur or spark the conversation to what the law is right now, and presumably one would hope that the employer that you are interviewing with would actually know what the law is currently, so that you wouldn't be asked a question you weren't supposed to be asked. Just like under the ADA, you're not supposed to ask any questions relating to somebody's physical disability. You're certainly able to ask them whether or not they need an accommodation to do the job, but to get into that kind of question, it's the same kind of thing that employers should be cautioned about, and we'll go through the various state laws in that regard.
Yeah, okay. I would agree. I think one of the big, the best way to deal with that is to sort of shift the conversation to a discussion of expectations. And it would be appropriate to say, my salary history is really not relevant here because I have not been paid commensurate with my skills and abilities. This is what my salary expectation is based upon my experience, my education, and my abilities.
Right, and actually following up on the second part of, I think, Deidre's question was, how do I find out what my peers are being paid and making sure that I'm getting an offer that's commensurate with that? There's a couple ways of going about it. One could, and certainly in a non-confrontational way, because you're obviously trying to get a job, you could ask about whether or not the company has salary grids or scales or bands that they employ for various departments, and specifically what they would be employing with respect to your potential department. And that's a way at getting some of that data. And if they don't do it that way, well, how do they determine the appropriate salary levels for their jobs, specifically yours? Kind of turning the question back on them. And to Erin's point, they didn't have, it may not even be the same job that they have currently. So obviously it wouldn't be, the salary history would be even less relevant to going forward.
Yeah, this is the challenge. The challenge is every human wants to make as much money as they can make at that given moment, right? And so the fact that it's even a negotiation is a problem, right? That right there makes it a problem for the word equality, right? Mm-hmm. Such that how can we have equality if there's negotiations? And so what I'm really hoping that comes from these laws is that takes that away, and that it pays what it pays. And, while that's going to bring challenges to employers, it's certainly, I think, less of a challenge than everybody's going to face if we're having these conversations of, well, I don't have to tell you because of this law, and, let me learn more now how to negotiate in brackets, and oh my goodness, And so it's really, also as a staffing leader, in the space, it's really hard to coach people, So I'm hoping, do you think we'll get to a place, just based on what you've seen, where we can, sort of, like I remember when Mazda and selling cars was the first in the 90s to say, no more negotiations, our price is our price, and I thought, oh, all cars are going to go that way. That's so cool, because there's nothing worse than negotiating a car, but it's gotten close because of the content we can get off the web and see what people paid and all of those things, it's gotten pretty close to that. Do you think that will happen in employment in organizations?
I think it may happen a little bit closer on a state-by-state level, but for any of us to assume that the federal government anytime soon is going to pass the Paycheck Fairness Act when it's been out there for 20 years now, in this current environment, and perhaps it's my Jersey roots, but I'm pretty pessimistic about it.
Yeah. Yeah. Is there reasoning behind it that's more than just, why? Is it just workload that they don't want to implement? They're afraid of, the support of implementing it? Or do you really think it's just a moral human thing?
No, I think it's just more of the fact that this current environment on a federal level has encountered a significant degree of difficulty with passing anything. So I don't see this being at the top of the list.
Right.
When you've got, debt ceiling is seemingly something that, and budget are two things that you would think would not be so confrontational, but they are, and they're not really getting anywhere there. So,
got it.
I think what you're seeing is more at the state level.
Yeah. The states are going to try and fill in the gap, so to speak.
Awesome. Well, tell us about that. I think that's our next slide.
Sure.
Slide, right? Yeah.
How about that? How convenient. So, looking at state and local pay equity laws, right now, all but 2 states have some kind of pay equity law, and the 2 states that don't have any pay equity laws, Alabama and Mississippi. And when you look at what's happening, you see now a growth of state legislation, because I think states are recognizing that, listen, nothing's going to happen on the federal level. There's a lot of pressure at the state level and even throughout the United States for ensuring that there's pay equality. And so what you're finding is that a number of states have gone to the forefront. Obviously, if you look at states out there that are in the forefront of employment laws and employment legislation, you usually start with California, and then you've got New York and Massachusetts not too far behind, and then some of the western states and perhaps some of the New England or closer to mid-Atlantic states. And that's not unusual with other employment laws that have been on the books in the last few years, specifically in the area of social media. So what you're finding is that these states, and the next slide points this out, what a shock. Recently effective, California, Maryland, New York. They've all recently had legislation go into effect so that these laws are on the books, and not only that, employers and employees are expected to abide by them. What you have on the horizon is Delaware, Massachusetts, Oregon, New York City, and Philadelphia. The reference to Philadelphia currently being stayed is the fact that Philadelphia had a law that was supposed to take effect in May of this year, the Philadelphia Wage History Ordinance, and it was challenged by the Chamber of Commerce. That was thrown out, but then the Chamber of Commerce filed an amended complaint, and currently that ordinance has still been stayed. Massachusetts, the law will go into effect July 1, 2018. That's not too far off in the distance. And so one thing to consider if Massachusetts employers that are on the line or perhaps people that are trying to become employed in Massachusetts, one thing to consider is, well, do you wait until July 1, 2018? Have you already made these changes so that you're transparent about what the Massachusetts Equity Pay Act has and whether or not you're abiding by it right now? Or are you thinking, well, maybe we should just roll this out January 1, 2018 to just get ahead of it? But start in January 1, just kind of with the calendar year end, so that you know that you'll be in compliance by that time as far as educating your workforce and training your workforce and managers. So what are the major themes? And obviously, I know everybody loves when a lawyer says it depends on an answer, and that is true to form with respect to the state and local pay equity laws. It really is dependent upon which state you're in, which locality you're in, perhaps, and that's generally with the localities. It's going to be a big city. That's generally par for the course. It'll be a big city. Otherwise, it'll be state laws. Well, what are they focusing on? Well, they're focusing on getting a little bit more granular with respect to some of what was on the books on the federal level, but really putting some teeth into the provisions. So, for one, defining comparable or similar or equal work, defining same establishment, protecting employees' rights with respect to just even inquiring or discussing it in the workplace. And that's always, something that I think in years past was considered taboo, and now you're going to be in a position where employees have certain rights that they're protected in that regard. And then you've also got, consonant with that, or consistent with that, barring employees from seeking information about compensation history before making an offer of employment. And finally, creating an employer defense to pay discrimination suits, which on that point is a little bit closer to the self-critical analysis privilege that exists with respect to affirmative action plans and the development of affirmative action plans and doing an internal analysis of the company. That's something that I think is being expected in that regard. So what about comparable or similar or equal work? Well, the four major ones that I would say the four major subtopics of comparable or equal work, looking at skill, effort, responsibility, and working conditions. In fact, Massachusetts includes that when they say work that is substantially similar, in that it requires substantially similar skill, effort, responsibility, and working conditions. And once again, this is where one particular law, and California and Oregon are similar in that regard. Well, these three states are trying to get more specific around the criteria that an employer can use when determining whether or not two positions are comparable.
That's hard. That's just fascinating when I think to myself, okay, bringing into sort of my everyday, let's say a network security architect who's joining an organization and they have 10 years of experience, and then they're joining with somebody that's doing the same job that's got 15 years of experience. So instead of just saying, okay, they're doing the same job, responsibility, right? Responsibilities. We're going to add on top of that effort. We're going to add on top of that, like, the idea of skill. Maybe one is a little bit, better than the other. However, they're still both very high functioning, right? Is that what's going to happen? Or are those two people going to make the same money? Because right now they're not making the same money, most likely, just based on the new person coming in. But they're doing the same job. Yeah.
On that topic, I think, the differentiator, and just going to the next slide to get even more granular on permissible wage variation, one has more seniority than the other, based upon the 15 years versus 10 years. So perhaps that is a theme that runs throughout your company. Now, it's certainly true in a bargaining union environment that seniority is the be-all, end-all. But it's certainly something that can be taken into account with respect to pay levels for different people. Once again, it's one of the things I think will come out of this media attention, and the media attention to this topic is because of the state wage and hour laws that are being put on the books, is that companies are going to do a little bit more of an introspective look at how they determine wage rates across the board, and if they are, in fact, relying upon seniority or relying upon a merit system. Somebody has a much higher rating than another person, and therefore they're getting paid more. But then you've got a whole host of other factors that are permissible wage variations. The question is whether or not the company is actually relying upon them. For example, if you've got an individual, one's got a master's degree, one doesn't, and the job description for the position doesn't require it, but you're paying the person with the master's degree more than the person without it, is that wage differential, whatever it is, really, is that value attached between the wage differential and the fact that some person has a master's degree and the other person doesn't, especially taking into account whether or not it's either required or preferred for the particular position in play. You then look at geographic location, education. Geographic location, obviously, the highest cost of living is, California, Massachusetts, New York, and taking that into account, even if they are the same positions, just the cost of living in one location versus another. And then what shifts there are, when people are working, what their job duties are during that time of the day, certainly another thing to take into account. So those are permissible differentiators that an employer can bring into play legitimately and lawfully. The question is whether or not they're actually doing it for those reasons, as opposed to trying to backfill and come up with a reason for why there's a differentiation. Another area that companies, or I should say the state and local laws, are really focusing on is the same establishment issue. And Erin alluded to this before. Well, people that work in the one building, they have all sorts of amenities and benefits, and they get paid more, and people in the other building get paid less. And we differentiate, and we're allowed to do that because it's not the same establishment. Well, Maryland and New York, for instance, basically say if they're in the same county, the same geographic proximity, so the same county in their minds, you're going to be expected to be paying people equally in that regard, and that the same establishment loophole will not really exist going forward. Now, what about employee inquiries and communications regarding compensation? Well, California, Maryland, New York, Puerto Rico, Vermont, Massachusetts have taken efforts through their pay equity laws to basically make a much more robust retaliation provision so that employee inquiries and communications are going to be protected activity. That's actually very very similar to what's happening at the National Labor Relations Board over the last few years. We'll see whether it carries forward, but at the NLRB, which has weighed in on union and non-union workplaces, the NLRB has taken the position that if an employee is talking about wages, hours, and working conditions under any circumstance, that would be protected activity under Section 7 of the National Labor Relations Act, and therefore a violation if an employer retaliates, an unfair labor practice charge if an employer retaliates against somebody for engaging in those discussions in the workplace. And I think one of the things that you should be mindful of is, all right, now we not only have the NLRB, but we have a number of states that are making much more robust retaliation provisions that employers and managers in particular need to know and be aware of so that they are not subjecting themselves and the company to retaliation claims. Now, on the flip side, that doesn't mean that it's the wild, wild west, that Massachusetts, New York City, Oregon, Delaware have created these provisions that prohibit employers from asking about salary history. At the same time, that doesn't mean that employers are required to disclose employee compensation data across the board to any employee or any third party. And in fact, the prohibitions that have existed in the past certainly still apply to managers and will apply and can apply to people that have access to compensation data that is not generally available within the workforce. And you certainly can create a protocol for making inquiries about compensation data and how that is basically the avenue for doing so. So it is not an open-ended effort to allow employees free access to all the company's compensation data, which in many respects will be considered confidential and proprietary. Here it's giving employees some protections with respect to their own compensation vis-a-vis other people in their department and in their same job category, while at the same time protecting employers in their ability to manage disclosure in a legitimate, reasonable way.
Yeah, and also really to protect some of the privacy concerns that some individuals have about their own salary information. So an employee really, what you see are some of these laws is an employee can't go to HR and say, I want to know how much so-and-so makes. HR would be barred from disclosing that information without having that individual's prior authorization, because we all do have some privacy interests in our own salary.
Fascinating. I mean, the law is created to protect women, and thankfully so. And while we're seeing improvement, we know that there's still a lot of work to do, which is why this is still a hot topic. And yet, with great intentions come challenges, right? And one of the challenges, and the biggest one that I keep bringing up, is just this negotiation of salary, which in my world of technology and tech, which is where I spend my career, which is 90% men, it's the men that are also trying to figure out how to take advantage such that they're not getting, let's say, a lower offer than somebody else that's working in the company who may have been there for years prior, but they're doing the same job. And so that's what I see most of, in my world. I've certainly never worked for an organization where there was discrimination of women's income, thank goodness. I'm lucky that way. That being said, we need to correct that, and I'm really hoping that this brings the awareness, like you said, such that people just get with it. and yet it also is feeding this massive, mental space of job seeking and negotiating income, negotiating salary. We're seeing it almost daily now from job seekers, really, trying to utilize this law to not have to negotiate or negotiate in a different way, and it's actually turning employers off.
Yeah, I could see that, and I think you're probably seeing the most action on the issue of what employers cannot ask. I presume that's where you're seeing the most action. Yeah. Yeah.
And as a staffing agency, what's our responsibility too, right? So we don't want to send somebody to a job that can't pay what this person's looking for, but yet what they're looking for is never really what people accept, because it's really not about the money, it's about the opportunity, but sort of, the pre-getting them to the opportunity, money's talked about, it's very complicated. And then, okay, let's say we go down that road and we make, the interviews all happen, and now we're at the offer stage and it just doesn't work out because of the lack of clarity of the income. Then what a waste of everybody's time, and we've seen that just recently. Too many times for my comfort.
Yeah, and I think where getting into the expectations discussion right up front, especially for staffing agencies, is probably the best course. If you have to do, you have to weed through the hundreds, thousands of people that you have in your database in some manner. And pay is going to be one of those levers. And if it can't be salary history, the proper way to deal with that is salary expectation.
Okay.
As a screening device.
Tricky, because again, I can tell you, and the statistics show, particularly in technology, people aren't leaving because of money, and yet when they are interviewing, they don't want to, they want to negotiate the best deal they can, so they think this is the way to do it. Mm-hmm. And I'm thinking it's not the way to do it. So it's going to be a big challenge. Interesting one.
Well, I think it goes to the issue of transparency and, being knowledgeable about the law that applies to the particular company that the person's interviewing at, making sure that everybody's on the same page with respect to what the law is, and then laying out, expectations, as Erin says, will hopefully give everybody the ability to kind of get to the right answer. Is negotiation going to go completely away as a result of this? No, I don't think so. I don't think it's going to be as close. I mean, and even in the car industry, as much as you do have more intel and data with respect to, say, Carfax for one, you certainly still have a fairly extensive negotiation. And I only know that because my father, who's 79, just leased a car, and he was quite proud of the amount he got on the monthly level, and it was a matter of negotiation over a period of a few days. So that's not gone away there in that context. I don't think it's going to go away in this context. One of the questions that came up, well, is severance, does equal pay laws apply to severance as well? Well, number one, severance is not a wage under at least Massachusetts law. I don't know that it's been interpreted as much in other jurisdictions as a wage. So it's not covered by, I believe, any of the state or local pay equity laws that are coming out right now. And there, it's not. It's really going to depend on what the policy and practice of the company is, whether or not they have a policy or practice, and then whether or not they're doing something as a one-off for whatever reason related to the person's separation from the company, which is a little bit more nuanced than, say, what somebody earns in the same position at the same department and with the same level of experience. It's a little different when you're dealing with the separation and whether or not severance in one amount may be justifiably higher or lower than for another person.
Right.
So, we've already talked a lot about this, so I won't spend too much time on this slide, but I do want to point out that Massachusetts was actually the first state to prohibit employers from asking applicants about their salary history, and that ban is going to go into effect on July 1st of next year, so that's coming up. New York City, Oregon, and Delaware have also followed suit, although their effective dates are a little bit earlier. The ban in Oregon starts early October 2017, New York City end of October of this year, Halloween, and Delaware will be effective December 14th of this year. Philly would have followed suit as well had it not been stayed, as Don had talked about earlier. And we're also seeing that California and New York State are trying to jump on this bandwagon with some proposed amendments, and I predict that we can expect to see more states, possibly many more states, adopt this type of a model. Basically, what these sorts of laws look like is they're saying that employers can't ask applicants about prior compensation before the offer of employment and the compensation offer is made. They can't ask applicants, current or former employers, for compensation information, so you can't do an end run by going to their references for that information. And all of this is getting to the point that they can't screen applicants based upon their compensation history. And I think it's clear what the point there is to put an end to the historical wage gap that exists. There are some ways of getting at some information. Employers can ask applicants about their prior compensation after the offer of employment or compensation is made. What you're going to do with that information at that point, I'm not sure. I suppose you could use it potentially for future promotional decisions, although you would still be bound by the laws prohibiting any kind of gender-based wage gap. So, even armed with that information post-offer, there are significant limitations on what you can do with it. Employers can still ask applicants, former employers, for compensation information after the offer is made as well. And one nice thing, I think, I know, Deidre, that you said you've seen a lot of employees sort of asserting rights, sometimes prematurely, to not disclose this information. But a lot of folks don't know about these laws as well, and a lot of people will volunteer this information. Some people will volunteer it even if they do know the laws, especially if they think it may be helpful to them. Once somebody has voluntarily disclosed their salary history to an employer, it's basically fair game, and the employer can then verify that information by contacting the prior employers.
Wow.
Yes. So once
I was just going to say, so filling out an application, does it still ask for salary history? If they actually put that there, then that gives the employer the right to check that number with previous employers.
Well, the issue there is that if you're in a jurisdiction that has one of these laws, you shouldn't be asking it on the form to begin with. So right then is your issue. It would have to be if let's say the form asks for the individual's salary expectation.
Or salary range.
Range of expectation, and the applicant fills out that section by saying, I am currently making X. They've offered that information, although it was not asked for, and now that opens up the door to verify that information. Sort of like they've let the cat out of the bag.
Right. Interesting. And to your previous, where the employers can ask for compensation information after they've accepted and started, does that person have to give that information? Can they be terminated for not giving that information, or is that just individual companies' policies?
Yeah, no, that would be an individual policy. I don't. There's nothing.
I wonder. Yeah. Okay. I mean, I bet you tons of people aren't going to want to give that information. So I'm thinking, what's going to happen then? Okay, so now is there going to be a problem within HR? Interesting.
Right, and again, it's probably of somewhat limited utility in light of the other provisions under most of these laws.
Yeah.
I want to talk a little bit about this self-evaluation defense. This is pretty limited. Massachusetts and Oregon and Oregon's laws provide some kind of a defense for employers that conduct basically a self-audit. And we could talk about the value of self-audits on their own, but here is some additional benefit to doing them, at least in Massachusetts and in Oregon. In Massachusetts, the self-evaluation defense is an affirmative defense. If an employer does one of these self-evaluations and it's reasonable in detail and scope in light of the employer's size, then it's an absolute defense to a claim under Massachusetts pay equity laws. If the employer does a self-evaluation, but it's found to not be reasonable in detail and scope, let's say you just kind of flub it because it's your first time or we haven't gotten any guidance yet from the Attorney General's office, the employer would then lose the affirmative defense, but still would be off the hook for double or liquidated damages. So you can limit your liability basically by going through the best effort of doing a self-audit. In Oregon, it's a little bit different. It's a limited defense, so you can't get yourself completely out of the water, but it does limit damages to 2 years back pay and fees and costs. And it seems like it's a little more difficult to satisfy. It does require more than just reasonable progress toward eliminating a pay gap, which is what Massachusetts requires. It actually is requiring that employers eliminate wage differentials for the plaintiff and also make substantial progress toward eliminating wage differentials overall. So Oregon's a little bit tighter. I think, these two things, it kind of remains to be seen. We haven't received any guidance yet from the Massachusetts Attorney General's office on what a proper self-audit would look like, although they have indicated that they would be providing some templates, forms, and guidance. But I think, there's a benefit to doing this anyway, regardless of where you are. If you're in a jurisdiction that is focusing on pay equity, and eliminating these wage gaps, always good to know where those wage gaps exist in your workforce so that you can address them in a proactive manner.
Yeah, absolutely. Absolutely. Will when those documents or that assessment, something that anybody can just download from the Attorney General's website, or when it comes out?
It should. I wish that these things would come out earlier than they do.
It never happens.
It never happens. So if we get this guidance before the law goes into effect, I will be very excited about that. And it would be posted on the Attorney General's website. These forms are always made available publicly.
Awesome.
So a little bit more on the self-evaluation defense. In Massachusetts, there are some limitations on how they can be used. The point here being you don't want employers being afraid of conducting self-evaluations because they might uncover something that they've done wrong. And then what do they do with those documents? They don't want them to be discovered if there were ever some legal action. So how do we deal with that? And what we're seeing is that these laws are providing some protections around those corrective plans and self-evaluations, basically saying that they cannot be used to prove that violations occurred before the self-evaluation was completed, and things like that. It basically cannot be used in other legal proceedings. In Oregon, it's actually an even greater protection. It says that in Oregon, that self-evaluations and corrective plans are inadmissible in any other legal proceedings. So that's basically just to make sure that employers feel incentivized to conduct these audits and aren't afraid of having their dirty laundry aired as a result.
Right.
Right. And on that point, you should use legal counsel to ensure that all the protections are put in place so that you can then assert that privilege in the right context.
Mm-hmm. Right. Right. Meaning you could do that wrong. You could still do the assessment. You could do the assessment in a way that it could be utilized in the court.
Yes.
Exactly.
Yes.
It's worth noting that there are several other common employer defenses that we hear that will not be recognized. So what is not a defense, or let's say our top two lamest excuses, that the employee agreed to work for less than equal pay, that will not fly. So even if in the negotiation the employee says, I just need another job, please hire me, I will work for peanuts, that's not going to win the day. And again, previous compensation history is not fair game in terms of implementing any kind of pay disparity. So other kinds of key provisions, and I don't want to get, as Don pointed out, all of these various state and local laws are all unique snowflakes, and they all have their own enforcement provisions, damages provisions. But generally what we see for enforcement is that anything from the administrative level, individual causes of action in court. Some of these laws provide that the Attorney General may pursue claims on behalf of employees, as well as class action procedures. So it really does run the gamut. For damages, again, it's running the gamut from unpaid wages. We see 2 or 3 times in liquidated damages for the unpaid wages, compensatory damages, punitive damages, injunctive relief, and fees and costs. So it really is soup to nuts on damages depending on which jurisdiction you're in. And again, the limitations period similarly range anywhere from 300 days to 6 years. New York State has a 6-year statute of limitations.
That's like a breach of contract claim in Massachusetts,
yeah.
Or in many other states, 6 years.
Yeah, and it's pretty consistent. All of these laws do contain some kind of anti-retaliation provisions. And I know in Massachusetts, the Massachusetts law specifically states that no male employee shall receive a pay reduction in order to comply with the law. So these are all upward movements in pay. I haven't seen that. I'm trying to think if I've seen that in any of the other laws specifically spelled out, but I think it would probably be a best practice to avoid that, reducing other people's pay to bring people in line.
Fascinating, but I could see people doing that.
Yes. From a morale standpoint, probably not the best course, but also from a legal standpoint here in Mass. Yeah.
Awesome.
We've gone through a lot of these already, but just to sort of to recap, what are some of the next steps for employers and staffing agencies? First and foremost, know where your employees are and know which laws apply. And I should add state and local laws there to that first bullet. Review and update your job applications. Deidre, you've raised this a couple of times. Make sure your job applications are not asking for information that they should not ask for. Review and update your interview notes, guidance and training materials for anyone who's engaged in the pre-offer hiring process. That could be staffing agencies, recruiters, HR, interviewers. Everybody needs to be on board with these changes. And going back to Don's point, it may be wise to start implementing some of these processes a little bit before the deadline. It does take time for people to get used to asking things in a different way, avoiding certain questions. So not a bad idea to build in a few months on the front end for folks to get up to speed. Ensure that your job placement screening processes no longer pull from pay history data. Sometimes that's just, settings in a program, but make sure that's not happening anymore. And conduct new training to ensure that everybody is aware of all of these legal requirements, anyone who touches the process.
And really on the last slide and the last, click that one, really this is kind of requiring you, if in fact you're working for a company that has offices in a variety of different locations, and realizing that a number of these state laws haven't gone into effect yet, or even are on the books, or even passed, but it's clear that this next wave of legislation is going to happen in this area, and it's going to be at the state level. Well, obviously, you got to really take a hard look at your policies internally and what they say. And if you're using a staffing agency, what does the MSA, the Master Services Agreement, say with respect to compliance with state equal pay laws? Obviously, you've also got to be cognizant of the issue of single employer, joint employer doctrine, and how that may impact the relationship between a company and a staffing agency, and really consider whether or not it's time now to do a self-evaluation and retain legal counsel for that purpose, to ensure that the umbrella protection, that is the safe harbor provisions of various state laws, are ones that you've comfortably fallen into.
Awesome. Thank you so much, Don, Erin. We're running out of time here. We have questions that we haven't answered. We'll make sure they get to you all so that you can answer. I can tell you, as somebody who's in this, every day, this is extremely helpful, and I will definitely be talking to you all about a guidance on assessments. So thank you so much. This is very helpful.
Take care, everyone.
Have a great day. Yeah. Have a great day, everybody. Take care. Bye-bye.
Bye.
Bye-bye.